Good afternoon. I'm going to go ahead and call the Rules Committee to order this afternoon. I'd like to welcome all of our guests and thank you. I'm glad you had traveling grace to get here and be with us. Let's all stand and we'll have our invocation, please. Councilman Keener, will you lead us, please?
Yes. With the greatest of adoration to the Heavenly Father, Lord, we thank you for the beautiful day that you have given us this day. And Lord, and be with us throughout this meeting here, Lord. And Lord, and as we come together, that we focus our heart, mind, and soul into your standards of life. That thy will be done on earth as it is in heaven. And Lord, keep us reminding at all times, Lord, that we're here for a service. And Lord, just help us now to serve in a manner that would be pleasing to you. We may not like it, but Lord, we want you to be happy. Lord, again, we want to thank you for all things that you have given us, and thanking you for the blessings and health-wise and all others, Lord. And Lord, please not forget our military people, wherever they may be. And Lord, we just ask, keep them safe from harm, and Lord, we'll be returning home soon. So as we go into this meeting, Lord, watch over us, take care of us, and we thank you for the blessings that you bestow upon us. In Jesus' name, amen.
Amen. Thank you, Johnny. Next, we'll have the roll call, please.
Meredith Brady, Joe Crittenden,
Here.
Gil Anglin,
Here.
Bill John Baker,
Here.
Jack Baker,
Here.
Audra Connor, Don Garvin, Chuck Hoskins,
Here.
Bill Johnson,
Here.
Taylor Key,
Aye.
Johnny Keener,
Here.
Jackie Bob Martin,
Aye.
Linda O'Leary, Melvina Shottown, David Thornton, Carrie County Watts, Phyllis Yarden.
Have a quorum. Next item on our agenda is approval of the minutes of January 25th, 2007.
Second.
Have a motion from Mr. Buell. All in favor, aye? Any opposed? Minutes are approved. I talked to Meredith about reports, and she said she would request that the written reports be entered today. If any of us had any, she didn't have any input? Okay. She was going to call over here at the council house and talk to one of the ladies and ask them to tell them to submit written reports. Is there anything from anyone that normally reports to this committee that they need to tell us that they can't turn in a written report form? Ms. Morgan.
We have material, but I had, we prepared a packet, and we'll give it to you in just a minute, but I have one or two things that I want to let you know at this time.
Okay.
Red cards. Mine came yesterday, and it had my name, my district, and Stillwell on it. And we've been talking to the company, Mr. Rainey, and he said they did a test run of those red cards, and they came out correct, the first test run. The ones that people received, I guess it's another entity of theirs or someone that they have contracted, didn't come out that way. Mine should have said Wilma Mankiller Center.
Yes.
So the phone rings every half minute. And they've spent all day doing that, but most of the people that are inquiring have the absentee ballots, and they've received those absentee ballots, and they are being sent back daily. Okay, and it will be corrected by the June election. But we did what we were supposed to, and they thought they had done what they were supposed to, but it didn't come out right on the red cards. Have you gotten yours? Anyone today?
I got mine yesterday.
Me too. Did you read it?
Mine says District 1, Precinct 1. It doesn't say Sequoia High School. It doesn't say, it just says District 1, Precinct 1. So is that right?
The material that we're going to give you, just in a second when I hush, is this material that you will need, and I gave Mike Miller a complete copy, and all we can say is that it happened, and I'm letting you know what I know at this point. Okay, let's see.
Mr. King has a question.
Okay.
I've been getting a lot of calls from folks concerned, that they may not be able to go physically if they're at large and vote. And I believe that there is provision for several days. That if you just clarify so that we can let those folks know.
Tuesday, Wednesday, and Thursday of next week over there will be a place to vote. We will have the company there. I will be there. The staff will be there, and a marshal will be there. Those people that are going to show up at a site where they usually went to vote before, if there is any problem with at large or on site, they can do a challenge vote ballot. And that ballot will come to the commission, and when it is opened with all of the others, then it will be, as an absentee, it will be considered.
Okay, can you just explain that again? Challenge?
I'm trying. It is so much to absorb, I know, for me, and I'm trying to make it as simple. Okay.
Patsy?
Yeah.
Mr. Henry's wanting to say something or help out a little bit.
I believe that is like a provisional ballot in the state of Oklahoma, where you walk into a district, they can't find your name, you can cast a ballot, they put it in an envelope. Here we call it challenge ballot. In the state of Oklahoma they call it a provisional ballot. And then it gets cast, and there's a decision whether that person is registered to vote, and if they are registered to vote, the vote's cast.
Okay, for example, I'll just use the test case.
Yes. A student always corrects their teacher.
The test case is a live person, is a Cleveland citizen from Kansas City, and is wanting to come in to vote. So they can, on March 3rd, they could go into any precinct anywhere and say, I would like a challenge ballot. Or they can come earlier.
Yes.
Okay.
No, I'm not.
Okay. Also, just a comment was in the Tulsa Cherokee Community Organization meeting, and on behalf of people there, did not receive a ballot, and they were concerned, and they were registered voters, and I'm sure, to me, it seemed like a pretty serious problem. I'm sure that they've all called your office and hopefully got it cleared up, but it just...
The reason you don't have your folder right now is because most of that is in there, but I assumed that if I gave them to you at that moment, you'd look at them and wouldn't listen. Isn't that awful to say something like that? Because that's what I do at a conference. If they give me something to read, I read it and don't listen. But let me get back to that. Some of the material we'll get, would you hold that question till we get it, and then I will get back with you as we go through? All right.
Thank you.
16,500 at-large letters were mailed. Okay. 4,505 have come back at this time. If you want to, you do numbers. You want me to repeat that? 16,500 were mailed. 4,505 asked for absentee ballots. And then we had everything in between, and you will see that when we look at that form. Some people marked their home district and at large. Some didn't mark anything, and so we keep every scrap of paper. And the phone has been busy today looking up, I did mail that. Well, if they mailed it, it didn't get to our office, because I go about every day and we go through that, and everything's in stacks and whatever. So is there a question? There. So many people did not fill out their forms correctly. If you want to be at large, you can't be at large and vote in a district as well. Okay. Let's see. I want a clarification on something that was brought to my attention, that I might have been opening ballots for voting. No, the day that I work, I take a little machine and run them through there and lay this here and then separate them and lay them out. The ballots will go to the post office, and we will not get them until that day, and they will be brought by Marshal Service down there, and 5 members will open them and look at them and put them in these appropriate stacks. Okay? All right. Rick Doherty is here, and we are going to hand these out, and I don't want to take very much time on helping. He's another member of our commission. Rick, do you want to add anything? They may not be in the same order. 3 of us did it. Page 1, special election. Here is the letter that went out. You can look at it later if you wish. Then here is the form, and down at the bottom we changed it so that it would be larger. I wanted it in red, but it would cost too much, so we didn't do it in red. And to say I mark Stillwell and at large, then nobody knows where I'm going to vote. But that's why we have the challenge ballot, or go there if you don't get what you need. The next is what went in the mail the last of December or 1st of January, giving instructions, and they are supposed to send this back. Do not mail or bring until January 11th. There's a ballot. This is Cherokee Nation precinct locations of the information that we really need, because those red cards are probably...
Mr. Baker's got a question.
So from reading this, I'm assuming that my red card should have said District 1, Precinct A, instead of Precinct 1.
I am too, because
Okay.
when we didn't address A or 1 when we were doing this.
Yeah.
Okay, and here's your map. I'm sure you've seen it before. And then here is your election commission dates and information. And if you have, and your other dates, and here is the suit from D.C. at the very back. And so if you have other questions, I don't want to take any more time.
Any other questions? Raymond, go ahead.
Did you say anything about how you were going to correct the precinct and what the precincts were? You got to put them in the newspaper? What are you going to do?
Mike Miller got the information, and he's going to make sure that that information gets out, and everyone that calls that is worried about that, that's calling, is out of bounds. And they say, do you have an absentee ballot? Yes, I have an absentee ballot. They said, don't worry this time, it'll be correct next time. You have that.
Buell? Go ahead, Buell.
Mr. Chairman.
Yeah.
This morning. In the future, when we send stuff out, since we, during the Election Reform Act, that we changed the district from Uligal to Keeler, should some of these things not be corrected instead of continuing to send out maps and stuff that says Uligal district? And I think that's going to add.
If you'll correct it and get it over there, they will. I mean, if you see something that needs to be corrected, yes.
Okay. Yes. Could I yield some time to Todd?
Am I finished?
Yes, go ahead.
No, I was just going to state that I'll review it, get with all of you what corrections or additions that you perceive we need like that. I'll make sure it gets
Okay, thank you, Todd.
Okay. Tammy?
I just have a quick announcement. You may already be aware of this, but I just want to make sure that you are. February the 15th, there was a joint resolution for funding 2007, and that was at 06 appropriation levels rolled into 07, What that means to us, DOI took a double rescission. There was a 1% across the board rescission. DOI took a .476 rescission on top of that. On IHS side, there was $126 million that Congress did not give instructions as to how IHS is to spend that. So they've been given 60 days to come up with a spending plan to submit to the Office of Management and Budget. And they are currently in the process of doing that, how they're going to divide those funds. Also, it was funded at the 06 level, but it removed the earmarks. So even though the money's still there, the earmarks have been removed. Senator Stevens from Alaska, the funds that he has earmarked for Alaska, those have been removed. So that'll be good for all the tribes.
Okay, thank you. Any of the other reports need to be, anybody needs to make a comment about those, or can you submit them in written form? Appreciate it. Mr. Martin, you have something?
Yes, Mr. Chairman, if you allow me, if the folks are through here.
Yes.
I'd like to make a motion to amend the agenda. Two things, if the committee will allow, need to add John Cripps for confirmation and appointment. Put that down at the end of the new business would be one. And another one, I'd like to ask the committee to, same motion, to do item 7 under new business before we get into the unfinished business. That's my motion. And I know we've got a lengthy agenda here, so I hope we'll speed things up.
Mr. Chairman?
Let me ask Mr. Martin a question for clarification. You want to move number 7 on new business?
Yeah,
To wrap
this up before we do unfinished old business.
Before you finish old business?
Yeah.
Okay.
Does that make sense?
I have a motion on the floor to amend the agenda. Did I have a second? Yes, Mr. Rowe.
Motion.
Okay, I have a motion and a second to add one agenda item. I guess that would be number 9 under new business, and that was the reappointment of Judge Cripps.
Yes.
And the other was to move item 7 under new business up. Pardon? Yes, to do it now.
Right.
Before we start the old business. Okay. I have a motion and a second to that. A vote. All in favor? Aye. Any opposed? Okay. If we're done with our reports, then we will attend to the item 7 under the new business. Officially, it's been moved now to right above old business. And it's a Freedman Dawes Roll presentation. Marilyn, are you ready to do that now? Would that be...
Doug will have, Mr. Evans will have to turn the machine on, so we're almost ready here. We didn't realize we'd be right this second.
I understand, and I apologize for that.
Well, no, sir, that's fine. We're glad to accommodate Councilman Martin.
It'll come on. Say anything on that little window? Okay. Hit that power button again right there. Yeah.
Marilyn, this is like a 15 to 20 minute.
Right, yes, she told us, 10 minutes for me and 10 minutes for him, so I got my...
I'll get out of the way here.
Okay.
Have you got any juice then?
Well,
I set this up about an hour ago, and it was running.
We've been sabotage.
Well, it was on earlier.
This corner, look, this is on. That's the main thing.
Towers on it,
Hey, that's a brilliant one there.
500 people requested, sent in their absentee ballot requests, and they received.
Oh, boy. Yeah, that's funny. It was working
That many
earlier.
people are going to vote for absentee.
That sure is.
They mess up though, you say that?
Oh, yeah. This one, like, don't mind it. Yeah, and after all the instructions, the people are messed up. They called them and sent them one back and had them do it, so we're still getting those that we sent back. Say, I just would have voted still with them. And then I lived over in Arkansas.
She should
Gail, he's got a green line up there.
Yeah, I'm talking about, and that letter explains it.
What's that plug right there? Is that plugged into something?
it looks like it's pulled out.
Couldn't have a green line.
I'm going to have to pay attention.
Does that have something to do with it?
Well, 16,000.
And bad addresses fill 3 boxes and
So the majority of the people in my
Well, we didn't have to start right on
category, or they did choose one of the rules.
still going to be, the majority of those are going to fight that. Maryland may not.
Can you reverse, can you do
Yeah, we
part of the presentation while someone works on this, maybe?
Yeah.
Can you do that?
Yeah, we can go ahead, I know everybody on the council, they have their package, I know things.
I didn't do nothing.
I voted absentee.
There we go.
I knew he does it. I told him how to do it.
Come on now.
It's coming on. It's coming up.
Oh, is there something on there?
Yeah, it's coming.
Okay, I couldn't see it.
All right. We'll get there.
Wait.
You may want to wrap that down.
Pardon me?
Oh, okay, good. This one, my package.
We're getting ready to start, and we can, lighten that this little.
Okay, I want to thank the council for allowing me to have a presentation. Again, I'm Marilyn Van, President of the Freedmen's Association. And the council, it's this white handout that hopefully everybody has, and that the rest of you can see up there on your screen. I have like a table of contents there on the first page. The second page, which is up right now, shows the various sections of the Dawes Rolls. Now, I get a lot of calls, and I get a lot of emails. People ask, well, are the freedmen on the Dawes Rolls? Are they not on the Dawes Rolls? Or are there Dawes Rolls and freedmen rolls? Well, you're seeing, based on what the Bureau of Indian Affairs has put down as what the Dawes Rolls are, which were approved by an act of Congress back in 1907. Cherokee by blood, there are some rolls there. Delaware Cherokee, Freeman rolls, Cherokee by your marriage. It's all there. Again, I'm not going to come before this council and just give my opinion. Anything that I say, I always try to back it up. Okay, so there they are. So if anybody asks, these are the Dawes Rolls. Now, we're going to the next page. Really doesn't have too much information on it, but this dealt with this document that you're looking at. It was given to the Cherokee government in 1975 in conjunction with a judgment fund. And the people that were on the previous page were some of the community leaders that were involved. So, I only say that because there are stories going around that the Cherokee people didn't know back then that the Dawes Rolls and the Cherokee by blood rolls weren't the same. So again, I provide you with evidence in case your constituents ask. Next page is from Angie DeVoe's book, And Still the Waters Run. One of the things that I have pointed out to the left there is it says a law of 1839 by which a Cherokee moving out of the nation lost his citizenship unless readmitted by the council was also sustained. Now, the reason I bring that up is that there were a lot of people who didn't get on the Dawes Rolls that were made, again, by Congress in order to allot the tribe's lands. And that's because they were not seen by the tribe as citizens anymore. And so people who ask, well, what's the difference in the freedmen people and the people that say were on the Henderson Roll back in 1835? Well, the freedmen people didn't abandon the tribe. And a lot of these other people went off because they wanted to be white people. So, again, I'm not just giving my opinion. This is what the book says the law was. Now, the next page, I hear a lot of other folklore around that the freedmen are going to take over the tribe, or there's 40,000 of them, 50,000 of them. I've seen documentation that's been passed out. Well, is this could this be true or not? Again, this is coming out of the Angie DeVoe book, And Still the Waters Run. This showed that at the time the Dawes Rolls were finalized, there were 41,000 citizens of the Cherokee Nation that the Dawes Commission enrolled at that time. Now it says there were 4,919 freedmen, which was a little bit more than 10%. So if there are 250,000 people in the tribe right now, and if every person who had received a freedman roll number registered, you would have around 25,000 max. So again, I only bring this up because I hear stories, and I've also seen things written that have been given to people, and so I want the council to have some information that they can use if they choose to use it. Now, the next page is still in Angie DeVoe's book, And Still the Waters Run. It talks about the law of 1908. The reason I'm bringing that up is it talks about restrictions. When restrictions go off for different kinds of classes of citizens. And so, depending on blood quantum, or if you were a freedman or a white person, then your restrictions would go off at different times. So I just want to point that out. The next page goes on to the case Sango versus Willie. In this case, it actually isn't a Cherokee case, but it deals with a Creek. There was a woman who was registered as 1/4 Creek. Her daughter was registered as a freedman. There was some dispute over selling an allotment, and the daughter said, I have Indian blood. My land should still be restricted. The court basically says in this case that for purposes of selling this allotment, this person isn't an Indian, but they are an Indian for all other purposes. Now again, this is a public record, and so one of the reasons I put this in here is to go ahead and prove, as I know some of you do know, that people some people were listed as freedmen, and their parents were listed with degrees of blood on a separate Cherokee by blood roll. Now, again, you can study this case at your leisure. The next thing, there is a case that's called Griggs versus Fisher, which is a Supreme Court case. And the reason I put that in there, the first page, is that it talks about the Cherokee Agreement of 1902. Any person that died prior to 1902 did not receive an allotment, or their name was stricken from the Dawes rolls, from whatever section. The reason this is important is that if a person was listed as a freedman and their parent had originally received a degree of blood and registration as a Cherokee by blood, their number would be crossed off. So that person's descendants nowadays would not be able to register and receive a certificate of Indian blood card because their parent died in 1901 or maybe in August of 1902. So I'm bringing this out because this was a law, and this is what has happened to many people. So anyway, you can look at the whole case yourself. Again, I just have a couple pages. The next thing, I have some sections from a few pages from the Dawes Roll books. So these are, I have the actual book in here. Now, again, I have a table of contents. And it just shows the same thing as you saw in the BIA book, the BIA document that I earlier showed you. The same things, the same rolls. There's no Shawnee roll. There's people that have been walking around talking about a Shawnee roll. Well, there wasn't. If you were a Shawnee who was adopted, you were on one of the other rolls. If your Shawnee ancestor married a white person, they were probably on a Cherokee by blood roll. If they married a person listed as a freedman, well, they're down there as a freedman. So, again, these are political classes of people. So, page 14, which shows a page there, it shows, this is from one of the pages in the Cherokee by blood rolls. You see people with varying blood degrees. You also see some people, AW, adopted whites. Mr. Graham is going to show one of those Dawes census cards that's associated with those people. Again, these are political classes of people. And so any person that was listed with as a Cherokee by blood, listed on that roll, they, based on the amendments coming up, their citizenship will not be disturbed. Those persons not on these rolls, it will be. But again, I'm just showing you a page. The next page is showing minors. Again, these are just political citizens. Everybody has, each one of these persons has a Dawes roll number, has a census card. These are children. Some of them are full bloods. Again, some of them are AW, adopted whites. For different reasons, their parents were Cherokee citizens. So again, these are public records. The next page shows Delawares. These are all the people who came into the tribe who were Delawares, citizens. Now, they may have been Indians, maybe not. If you look down there, you'll see some of them were white. Again, the Dawes Commission did not say they were Indians. They said they were white. So, again, these people's citizenships will not be disturbed. Cherokees by intermarriage, and I'm about to wind this down. None of these people had a blood degree listed. If a person said they were white, they were white. A person was listed as a freedman. The Dawes Commission did not list a blood degree for them. They did not say that the person did not have Indian ancestry, that there was no degree of blood by their name. The last thing that I want to show, since my 10 minutes are almost up, is the Riggs case, which is there. Went to the JAT. The JATs determined that Mrs. Riggs had Cherokee blood, although her people were listed as freedmen. Her ancestor that was a Cherokee had died, so she did not have an ancestor on the Cherokee by blood roll because her ancestor died. So the JAT has already made a decision that a person listed as a freedman can have proof of Indian ancestry. So as I said, I don't stand here giving my opinions, but as I said, the documents by the Bureau, by others, by the JAT. So I want to sit down, since my time is up, and turn this over to Mr. Graham, a professional genealogist who has served. He is not a Cherokee citizen. He is applying for Cree citizenship, but he has served as a professional genealogist and helped many people get certificates of Indian blood. So, thank you.
Did you say that the whites would not be affected by this vote?
That is correct. White people listed on the Cherokee by blood roll or the Delaware roll. I happen to have the Attorney General's opinion here because it says people who are listed on these, the only people who are affected are people who are have a roll number as intermarried whites or freedmen. I have it right here. I didn't have, yes, so I'm just going by what I have received that the Attorney General wrote.
Can I continue? Well, according to the ballot, I don't know whether you've seen the ballot, it says the Laws Commission, intermarried whites or freedmen rolls.
These are not intermarried whites I was showing you. The people that were there, these are people that are adopted whites listed on Cherokee by blood roll or Delaware rolls. They are not intermarried whites. Intermarried whites were people who were married prior to 1875, and they had citizenship rights because they were married to an Indian. There were other people who were adopted by reasons of paying money, or maybe they were adopted by the council at earlier times, but they were not put on intermarried white rolls.
Ms. Watts, go ahead.
I may need to yield to Mr. Henry real quick.
Okay.
Well, Mr. Chairman, I would request that the presentation stay focused on the Dawes Road and exactly that, instead of what is or what will not be affected on the election.
Okay, that's fine.
Okay, then I think my question is still relevant. Are you asking us to impeach the Dawes rolls and fix them?
No, madam. I'm just trying to say that if a person, because I get calls.
That's not what I'm hearing.
No, madam. I'm not. What I'm saying is the Dawes Commission rolls were for political purposes. They were made to allot lands. Because I ran out of time, I didn't go into some other things. There were people who were full-blood Creeks that were on the Cherokee by blood roll. There are people completely Caucasian on the Cherokee by blood roll. They were identified as white people, not Indian people. And so, what I'm saying is, if a person comes up to you and says, are there white people on the Cherokee by blood rolls who will not be impacted by this vote, then based on, okay, we're not going to discuss the ballot. The answer is yes, there are white people on the Cherokee by blood roll who said they are white, they are not Indians. There are people who the Dawes Commission took evidence.
Thank you, Mr. Chair.
Okay.
Mr. Baker's going to ask.
Yes.
Did you have your hand up?
Not yet.
I'm sorry. Okay, thank you, Marilyn.
Okay, all right.
Ma'am, thank you. You're up.
Okay.
First of all, I want to thank this National Council for letting me speak. My name is Ron Graham. I am the Vice President of the Descendants of Freedmen, along with Maryland. I am not a Cherokee citizen. Again, I'm affiliated with the Muskogee Creek, and I've been doing genealogy for well over 18 years. And what I'm going to show you is specifically about the Dawes Enrollment Census Card. What you have before you is in your manila envelope is a packet of what exactly I'll be going on. It's going step by step. This book is by Kent Carter, and on your first page where it has the Cherokee Phoenix, that was in your Cherokee Phoenix December 2006 article. And on the back of that, on the very back, It shows you the Dawes Commission. The first thing I'll be showing you, reading to you, is about the blood degree. Okay, in the blood degree it says, determining an applicant's degree of Indian blood proved to be difficult and became a source of intense controversy later when congressional legislation based restrictions and eligibilities for benefits on that. None of the roles taken before 1896 had included a blood quantum, and only a few of them recorded whether a person was full blood or mixed blood. And the only distinction most tribes considered important at that time. It appears that if an applicant did not claim to be full blood, the enrollment clerks estimated the fraction which they put in the degree of blood column on the official card based on the answers given about parents or grandparents. Some parents claimed to be full blood because they were afraid that admitting one of their relatives was not an Indian would prevent them from being enrolled. In cases where an applicant parent were members of a different tribe, the commission calculated the degree of blood based strictly on the mother's tribe. This resulted in the enrollment of a full-blood Seminole father and a full-blood Creek mother as one-half Creek, even though the child had 100% Indian blood. In cases of mixed freedmen and Indian parents, which was common among the Creeks and Seminoles, the applicant was always enrolled as a freedman and not given credit for having any Indian blood. And what I'm going to show you next are some of the census cards. This is an actual census card. We're going step by step in your manila envelope. You have Thomas Downing. He's down here as a freedman. And on the freedman census card, there's a front page and a back page. On the back page, it shows his parents. His parents is William E. Downing. It shows him as dead, but it's got down that his parent was a Cherokee by blood. And if you do further research on Mr. Downing, you'll also find that his father was a full-blood Cherokee Indian. And what you have before you is some of his brothers and sisters in that package. Due to time, I just showed you one of his, I just showed you his application. The second person is Frank Miller, step by step. If you have any questions or concerns, don't hesitate to ask me. Frank Miller is the same thing. On the back page of Frank Miller's application, his father is Cabin Miller, and it writes out right here that his father was a Cherokee Indian. You all see that on that second page? And again, if you do further research, Mr. Miller was actually a full-blood Cherokee Indian. The same thing, we have Sarah Cox, her family. You have Reed Van, Joseph Van, and so on. And their father was John Van. We just moved it right along. Now on the freedmen, that was it on the freedmen. But there are several cards, hundreds of cards similar to this right here, showing that they were Cherokee by blood. But the thing is, the only difference between a Cherokee by blood card and the Cherokee freedman card is that the Cherokee freedmen, the Dawes Commission did not list their blood degree. That's the only difference. They did not list their blood degree. Now this is a Cherokee card also. This is Joseph Bennett. Now, he's on the blood road by blood card, but he's down there an adopted white. Now, on doing his research, how he got his citizenship, he purchased his citizenship for $500. That's how he became a Cherokee citizen. And that's what it actually boils down to, being a citizen of this nation. What the blood degree did was put restrictions on your land or your assets. That's all the blood degree was. It wasn't for citizenship. It was for putting restrictions on your land or assets. We have George Martin. He's down as a minor Cherokee. And his parents are down as Cherokee by blood also, but they're down as adopted white. And if you read right in the middle of that, right in the middle, right here it says they claim they don't have any Indian blood, but still yet they put these people on the Cherokee by blood roll. Next we have Bird, a Robert Bird and a Richard Bird. They're also down as adopted white with no Cherokee blood, but they're all on the Cherokee blood roll. On the last card, you have Robert Lundy. He's down there on the Cherokee Delaware roll as white. It doesn't show a blood degree, but he becomes a citizen through a treaty, which is stated in his application. Are there any questions, concerns about any of these cards? Anything that I went over?
Mr. Baker? Sure. May I make some comments on some of these?
Oh, yeah.
First of all, I'll comment on the Joseph Bennett card.
Yes.
It shows that he was adopted white and that he was, and as Ron said, he did purchase his citizenship for $500. For a brief period, it was in the 1880s, for about a 6-month period, there was a law in the books in the Cherokee Nation that if a intermarried white's wife died or spouse died, then they could purchase their citizenship and retain their citizenship for $500. But he's the only person who did that under that law. And then later he married a white person. And then they have these children, and they are all listed on this roll.
Correct.
But that was one instance. Most of the other ones that are showed as adopted whites were descendants of Evan Jones.
Yes.
And in the 1870s, Evan Jones, for his longtime work among the Cherokees as a missionary, was adopted into the Cherokee Nation and given full citizenship to him and his family. And those are the other adopted whites that are on the record roll. So it's a very limited number, but they are.
It is limited number. It is.
Okay. And the Robert Lundy case is on the Delaware roll. He was married to a Delaware,
yes,
and his children were on the Delaware roll. So all of his descendants are Delawares. So there aren't any white descendants of Robert Lundy. There's other cases, and we look on page 22 of what Maryland passed out on the Cynthia Lynch, who was a Cherokee by blood, and she had a freedman husband, and she and part of her children are on the Cherokee by blood roll. She has 2 adult children on the Cherokee by blood roll,
yes,
and 2 adult children on the freedman roll.
Yes.
And it shows on the testimony on page 24 that the Commissioner's decision of September 18, 1903, the case of Cynthia Lynch, enrolled Cynthia Lynch as Cherokee by blood, but enrolls her children as freedmen. And the reason was for those 2 adult children, it says later that they applied for citizenship on the freedman roll and not on the by blood roll. And the testimony is actually in here on some of those. That shows that. And so this was the case of many of the freedmen that had Cherokee blood. They were placed on the freedmen roll because that's where they applied to be placed.
Well,
but there are also just as many. He said there's numerous cases on the freedmen roll that shows freedmen with Cherokee blood.
Yes.
There's just as many on the Cherokee by blood rolls that shows freedmen parents, because it appears that if the person was a freed slave born before the emancipation, they were placed on the freedmen roll because they in fact were freedmen. But after the emancipation, if they applied to be on the Cherokee by blood and were able to prove that their parents were Cherokees by blood, then they were placed on the Cherokee by blood roll. And there are numerous cases which I know about where there are parents that are freedmen shown on there. So a lot of it had to do with the testimony that was given to the Dawes Commission at the time as to whether they were applying. And in many cases, there was a Cherokee parent identified on the census card, or excuse me, a freedman who has a parent who was Cherokee on the freedman card. But nothing in the testimony shows that the parent was the Cherokee by blood. And I'm not sure why, because the census cards, and this is on the Cherokees by blood case too, in many cases the census card shows parents that are not in the testimony. And I'm not sure how that happened, because I don't know who filled out the census card, whether it was done before or after, or these parents were added later, because there are additions to census cards as late as the 1940s that the BIA went in and filled in additional information, which was rare, but it did happen. But my point is that there are just as many descendants of freedmen on the Cherokees by blood, and it depended on pretty much the testimony that was given in the Dawes Commission at the time. And I think that the Dawes Commission, where there are mistakes, as in degree of blood, on the Cherokees by blood, it's what was given to them in the testimony by the applicant. And that is what they went by, and pretty much all they had to go by, other than checking that they were on previous rolls. So I think the Dawes Commission did the best job that they could, based on the testimony that was given to them at the time. Thank you, Mr. Chair.
Well, other comments or whatever? We're running short on time. Marilyn?
I would like to make a real quick comment here, Councilman Baker, regarding the Lynch children. They did actually apply for citizenship by blood first. Again, we only had 10 minutes each, so we didn't want to deal with this. There were some other people, Sarah Cox.
Mr. Chair, I've gone through these pages of testimony on this family, and they did apply to be changed to the Cherokee by blood roll, 1905, 1909, and they were denied because they had applied as freedmen initially.
Okay. Well, obviously these types of important issues brings up lots of questions. We've expended our time, and we've got a long agenda.
And mine's an agenda motion.
Here's the agenda motion, and so I'd like for us to kind of move on with our meeting. As soon as Doug turns that light on, I can see.
Just very short. Okay. I just want to thank this National Council again for letting me present what I have. And like I said, if you have any questions or concerns, just give me a call.
Thank you all for coming. Thank you.
Mr. Chair, when I stepped out, I found out that Mr. Poteet had other business, and if we could move him up on the agenda. So I'd like to make that motion at this time to move him up to now.
Have a motion to move new business item 1 up to the next item on our agenda. Second. All in favor, aye?
Aye.
Yeah, you're right in, Mike Johnson.
I
Well, thank you for that. That light was killing, man. Okay, welcome, Ginger.
Okay, thank you. On behalf of the Principal Chief, I would respectfully recommend the appointment of Troy Wayne Poteet as a Justice of the Supreme Court.
I'm not sure which one of you was first.
Mr. Chairman, I move that we appoint Troy Wayne Poteet as Justice of the Supreme Court.
Second motion.
Have a motion by Buell, second by Don. Yeah. Discussion? Mr. King.
Thank you, Mr. Chairman. Is Mr. Poteet here?
Mr. Poteet is here for questions if you have any.
I would like to ask some questions.
Welcome, Mr. Poteet. Right here. Mr. King's going to ask you something.
Thank you, Mr. Poteet.
Could I have a moment, Taylor, before you start?
Please.
I would say that, like most nominees who have come before you before, I'll answer as many questions as I can. Most of you know me, so that maybe a lot of things that might come up wouldn't in a larger community. I would say that I will avoid being led into discussions of what's before the court. As I've told you in private conversations, and I've had one with each of you, I don't think that is will be a fruitful endeavor. I don't think I should do that. I think it would hamper my ability to function if you decide to confirm me to this position. But other than that, thank you for Councilman Keene for letting me.
Have we voted? Mr. Poteet, I've been fortunate to be your acquaintance for a number of years.
Point of order. We hadn't voted to move this up to the top of the agenda.
Yes, we did.
I think we did.
Yeah, we did.
There wasn't any opposition.
Oh, okay.
That was done.
All right.
Kara,
Yeah, but now-
let me ask a question. Kara, you made the motion to move it up, right? Who was the second on that?
Buell was.
Okay, because Gail was out trying to get the machine turned off and everything. Thank you. Go ahead, Troy, or Taylor.
And we did have the chance to visit at length, and I appreciate that gesture. What my concerns are, and perhaps you can help enlighten this council on, what your qualifications are in terms of your legal past. Have you, it says here you were in private practice. I mean, how many times have you brought cases to the Supreme Court, or numbers of Cherokees and that you represented?
Not at all, and that would not be my strength, as I've said to you in private conversations. I've never had a case in our court system. I did practice at the same time I took care of the riverbed from the time I went to school. My thought about that is that, and not, I think experience is great, and the more experience you have, the better. But sometimes you could have the same 5 years experience 4 times, and then you'd have 20 years experience at a number of pursuits that those of us in private practice would do, which might be bankruptcies, reading land titles, handling divorces or criminal matters, and all of those kind of things. I do not see those issues as particularly relevant to the kind of issues that come before our court. And what I bring that other people haven't to the court is I'm proud of my experience in the tribal government. I had 8 years of that, and then I can't remember how many years I've been working here. So I've been in the legislature. I've been in your seat. I know what it is to grapple with legislation. I know how the tribal government works. And so I have more than any person that we've had, perhaps since your dad, who had been a tribal employee, is the only one I can think of who I have a very good feel for what my decision might be, or what the court's decisions might be, what ramification that might have as a practical matter on the everyday working of this government. The other thing is, I have spent my life in the Cherokee Nation, except when I was off to school, and I didn't go far then. I came up out of the community with the elders teaching me to speak on the street with a tremendous sense of community, and I was very gratified when they allowed me to come here as their representative years ago and said I did a good job and I could come again. And I have a good connection in the community. A number of tribal courts have a layperson that sits with the court. Certainly I'm not a layperson. I'm a trained attorney. I have an appreciation for what we're going to be about. But that's what I bring, rather than, instead of 5 years experience as a everyday practicing attorney. I didn't have that same experience for 20 years. My background's in tribal government. So.
Well, thank you for your comments, Mr. Chairman. Just wanted to note to the council here that this is a 10-year appointment. Many of you all know, and Mr. Poteet mentioned, my father was Chief Justice of this court, and I certainly grew up in a household where that was taken with the utmost seriousness. And with all due respect to Mr. Poteet, I think that there are better qualified candidates for Supreme Court. We've got a lot of Cherokee lawyers out there, a lot of them with good experience, some of them sitting in the room here today. And I'd like to see someone with more qualified legal experience, especially with our Supreme Court. So I cannot support this nomination at this time. Thank you.
Thank you, Mr. King. Other comments? Troy?
There are a couple of things that I thought about. What would you say to the tribal council when you let yourself be put forward? And one of them is the workings of the court, the duties of the court. That's going to be my priority. I don't take this lightly. It's a tremendous responsibility. And I think that if the people honor you with that post, then that should be your priority, and it will be mine. I will be in attendance on the court and its functions and whatever is required of me there and whatever that I need to do. The other thing I want to say to the council is I'm one vote among 5, of course, but I believe that if there are matters before the court, the Cherokee people and their elected representatives have the reasonable expectation of a timely decision on those matters. And I don't mean that you hurry justice and you don't do the right amount of research and so forth, but I do not believe in letting matters just ride because you don't want to tackle the issue.
Mr. Baker?
Yes, and I too cannot be, and I told Troy Wayne up front the first time he mentioned this appointment to me. This is the Supreme Court of the Cherokee Nation. This is not a funsy deal. This is the Supreme Court of the Cherokee Nation. And to give somebody that is basically fresh out of law school, that has not practiced, that has not been a judge in some other venue, that has, in my opinion, zero experience for this position. that we are making a mockery of the Supreme Court of the Cherokee Nation when we know that we have Cherokee lawyers that are the brightest of the bright and have served many years already and have a tremendously more experience than Troy Wayne. And I don't think it's right. I think it's almost making a joke of our courts. And I don't mean that with disrespect. I think, 20 years from now, 15 years from now, maybe. But I don't think today is the day that we do it. And I don't want to get into too much personal, but, we've given Troy Wayne a shot at running the Heritage Center with on faith that he could do a good job, and it didn't turn out that way. They went from being solvent to a couple $100,000 in debt in a very short period of time. Many accusations.
Do we need to be in executive session?
No, this is all public record.
Okay.
I think we'd be doing the Cherokee people a disservice by giving a novice a slot on the Supreme Court of the Cherokee Nation. Thank you.
Call for question. Motion has been called for. We have a motion for approval and a second. In anticipating division, I want to ask for a roll call vote.
Thank you, folks. Well, thank you for your candor, Bill John and Taylor both.
Bill Angren?
Yes.
Bill John Baker?
No.
Jack Baker?
Yes.
Audra Connor? Joe Crittenden?
No.
Meredith Fraley?
Yes.
Don Garvin?
Yes.
Chuck Hoskin?
No.
Bill Johnson?
Yes.
Taylor King?
No.
John Keener?
No.
Jackie Bob Martin? Linda O'Leary? Melvina Shropouch?
Abstain.
David Thornton? Carol Cowan Watts?
Yes.
Phyllis Shargey?
Yes.
8 yeas, 6 nay, and 1 abstain.
Okay. Eight nay, 6 nay.
6 nay, and 1 abstain.
Okay. Next, we'll move into our old business items. Item 1 is the employment of relatives. Who is going to deal with that? Mason?
Excuse me.
Yes, Tom.
I think this is the one that I've been up on a couple times before on the
The ethics.
ethics.
This is a piece of legislation that has been before you for several months now. You've had the opportunity to review it. Mr. Morton and I will stand ready to answer any questions that you have about it. And your pleasure is ours, committee.
Okay. What's the pleasure of the council? Do you have questions concerning this? Anybody have any questions for Mr. Martin?
Mr. Chairman, I'm going to move for approval. Reason for that is we've been dealing with this for months, and we either vote it up or vote it down. Second motion.
Mr. Martin? No. Discussion, Mr. Baker's got a question.
We're moving to approve the act that's going to allow your kids and stuff to work for the Cherokee Nation. Is that the one we're talking about here?
Yes, it would allow that with certain disclosures. And it would also allow or require every official of the Cherokee Nation and every employee of the Cherokee Nation to submit a written statement of all outside businesses owned.
So now the employees can have side contracts with the Cherokee Nation.
That would all
For spouses.
Yeah, spouses would be able to have outside contracts with the Cherokee Nation. upon certain recommendations that are in the act. But everyone would have to disclose, appointed, elected officials and employees would have to disclose their business interests.
No, are you done?
I guess I'm done, yeah.
Any other, Meredith?
I never did get a definition of what doing business. Did we have a definition of doing business? Couldn't find it anywhere.
There is not a per se definition of doing business in the Act. The Act calls for, like I said, the disclosure of businesses that you or an employee may own, or would be able to then have a database to see if there's any cross contracts with those individual establishments.
And I misspoke earlier. If you look at 2810, disclosure of business interests, Part B, when they talk about employees, it says owned wholly or partially by the employee or his or her spouse. So I misspoke. It would also involve an employee.
Yes. That's on Section 28, or Title 28, Section 10B, which is the second page of the Act, at the very bottom.
It's the last paragraph. It begins on that page and it continues on the next page.
Mr. Chairman.
Ms. Fraley? Do you have further? Huh?
Thank you.
Mr. Thornton, go ahead.
What this does, gets rid of a nepotism law, right?
It would.
And I think that nepotism law is put in there to create us a check and balance for our government. I think this breeds corruption, and I think it brings legislators and their families to kind of a watered-down type deal, and it opens up the door for all of us elected officials and our families to just live off of this nation. And I don't think that's what nepotism law is in there for. I think it's just for the opposite. And I can't see this but nothing but pure corruption myself. And it brings funding into households that are yours and mine, that are out here that, our people are supposed to think about us being honest. And I think this just breeds corruption. It's just the way I feel about it. I think it's kind of ludicrous. I think we need the ethics laws that we have already and stay with them. And, I don't think it's too little to ask a person to run for office and his immediate family not be working for the Cherokee Nation in any form of way. That's just the way I feel about it. Thank you.
Go ahead, Mr. Chairman.
Mr. Chairman, I just wanted to clarify my answer. He asked if it would do away with our nepotism law. It would repeal our current law, and it would replace it with this modified version. I didn't want to sound
kind of
absolute.
What modified?
Mr. Baker.
What part does it leave?
Well, it would repeal Title 19, Section 51, which says members of the tribal council, employees of first degree, cannot be employment with the tribe. And what it replaces that section with, it states, no person shall be prohibited from employment by the Cherokee Nation government or its instrumentalities because he or she is a relative of an elected official unless the position sought is in the same branch of government as the person's relative who is the elected official. It goes on that says that if they are so therefore you're not prohibited unless, for instance, in this instance, if you have a relative, if you're a counselor and you have a relative, they can't work in the Cherokee Nation Tribal Council branch, but they could work in the executive or the judicial branch.
Ms. Shotbound?
Well, being around here for a while and this first time, and like I said the other day, we're not a company, we're a government, a sovereign government. And I heard the word diluted. That's right, we're getting so diluted. This Cherokee Nation is getting so diluted. We're getting so far away from what Cherokee stood for. And it pains me to see this. I have children, but as long as I'm on council, they'll never work for Cherokee Nation. But that's my belief.
Thank you. Any other comments? I just have just a general comment. I mean, I sort of understood what the nepotism was in the tribe, or the laws were when I ran for council. You know, I knew going in what was expected, and I accepted that. And I just look at, personally, I mean, this is water. We might as well, if we're going to do this, we pretty much might as well just do away with it. I mean, that's my take on it. Any other comments or questions? Jackie Bob was first, I believe.
Okay.
Go ahead and I'll deal with it.
I might add, I mean, I know why we're doing it, because I already heard out there somebody was promised that this would come if they would run for office.
Mr. Martin?
Thank you. Mr. Chairman, the reason I support this is our tribe employs so many people. Back the last numbers I saw, heard about, we have 3,000 more employees now than we had a few months ago. And we teach our children, or try to convince them, you know, to stay within your community. You know, don't run off to California or other places, you know, to get a job. Now, I'm not for this for my children. My children have a good job, they take care of themselves. But our children cannot help who they are. That makes sense. You know, and to me, this would afford an opportunity for our children or spouse or whoever to work for another department that I'm not even familiar with down there. That, you know, at least it affords them an opportunity to be able to work for the Cherokee Nation. I mean, we can come up with all kinds of ideas, I guess, but that's the reason I support it, is that it would. I'm too old to have children, you know what I mean? Personal problem. Yeah. But we have, you know, they might got children at home, and they might be needing a job here, and might want to work for the Cherokee Nation in the future. That's the reason I support it. Thank you, Mr. Chairman.
Call for question.
I got two more comments, and then we can, well, three. Ms. Yard, you hadn't had a chance to speak.
Thank you, Mr. Chairman. I just had a couple of questions. How does the nepotism law apply to C&E and C&I currently? That each of the entities have their own nepotism? Because I know currently we have a situation where members of families are working. For the record, I don't. You know, it's not to say that I wouldn't like for my children to be able to work for the tribe. I have said it before, and I'll say it again. I'd like to think that they have something to offer. They're familiar with the culture. They're familiar with their heritage. I would like to see them stay close to home, where they could bring their children up, where their grandmother could have some influence on their lives. And if those jobs we're creating are for Cherokee people, why are we going to be denying, them a right, not a right, but an opportunity to work for the tribe? We're not going to be selecting them. We're not going to be supervising them. And the jobs that are being created are for the Cherokee people as a whole. But my question was, even if we pass this law, or is it going to change? Does this law change or affect C&E or C&I, which I think is which I feel that's the target.
This law would draw a bright line, so to speak, and take that issue that you just described out of the gray area. Okay.
right now, Title 19, Section 51 says Cherokee Nation government, okay? Now, there has not been a case on point that has brought up and specifically challenged is, does that mean CNE, CNI? There are some cases that suggest that, but there has not been a bright line in it. Past this, there would be no question that, counsel, relatives within the first degree would be able to be employed with the Cherokee government and Cherokee Nation.
So the employees that are currently in place, that are in place in the Cherokee Nation government, the executive branch of government, not specifically the office of executive branch, but in the services over there, that, and this is not the first, we have some long-term employees who are family members of elected officials that have, so does it grandfather those people in, or do they, after 16, 20, whatever amount of years they've served or they've worked for the tribe, that do we say, okay, today then you no longer convert because this law is in place, or it's not in place, or you don't have a clarification? I mean, that's what I'm...
Well, right now, for the Cherokee Nation government, there shouldn't be any relatives within the first degree that work, that first degree of tribal members or tribal council members or other elected officials. So, there's no one really to grandfather in as to the government.
So this definition here that names all these specific people,
right,
that's not in place currently?
No. If you pass this, siblings and all these other definitions would be able to work for the Cherokee Nation government if they are related to an elected official, if that official discloses it and can go ahead and vote on, let's say they work for the health department, and let's say a hypothetical, you have a daughter, and this act passes, and your daughter goes to work for the health department, okay? Any health-related issue that comes up before this council, you would have to disclose that relative prior to any vote, and if you felt that there was no conflict, you could go ahead and vote unless a majority of the tribal council felt there was a conflict, at which point you would have to abstain.
You could also voluntarily abstain.
Right. But I said that.
Oh, I'm sorry.
Mr. Hoskins?
I would say this is one of those acts that I really can't believe we're even considering. I truly can't. We're the elected leaders of the Tribal Council of the Cherokee Nation, the greatest tribal nation in the world. We are the safeguard for the Cherokee people. We're the protectors of the first. I'm against this for the same reason that Jackie Bob is for it. Excuse me. I'm against it for the same reason he's for it, and that's for our children. We as elected officials have every right on earth to go over there when it comes time to file for office and simply say, no, I'm not going to, because I believe my relatives deserve an opportunity to work in the nation. And so I'm going to let someone else step forward. I'm going to let somebody else be in that position and help lead this nation, because I want my child to have the opportunity. We have 240,000 members of this great nation in this country. And you can't tell me that we can't get employees out of that 240,000 that are not directly connected in the first degree to the 17 members of this council. And again, it's up to each and every one of us as we file for office. Are we going to prevent our children from working for the nation by stepping out here and running for office? Nobody said it's fair, but that's the way that it's done. And it doesn't have to be completely illegal. All it has to do is give the appearance of being illegal. And we as representatives of this nation don't even want to have, or at least I don't want to have the appearance of even being possibly illegal. So as much harm as it may do to our individual families, and folks, we're just a matter of days or weeks away from being able to make that decision. If your child has been prohibited from being employed by this tribe or getting contracts with this tribe, the easiest solution to that is don't file for re-election. Let someone else do it, and let your child take advantage of this great nation employment opportunity and do that. But what I would like to see, this same issue given to the people of the Cherokee Nation to vote on in June. I would like to see them vote on this issue. And I would like to see how our people, the people we represent, would vote on this issue.
Amen.
And that's the same thing that we do when we cast our votes up here. We're representing them. And for that reason, I cannot and will not support this act. Thank you.
Mr. Keener?
Yeah, this is a rough one. I will not support it either because if we continue on, maybe not this year, next year, stuff like that, but we must kind of consider looking in a longer range. A little later on, it could be a family-run Cherokee Nation. And in many of ways, then later on, maybe just one man is running it. And maybe do away with the council. With all of that, if you get that power up there, that's our problem now. We're losing the power as elected officers, or as a councilman. I don't know, power. It's a power struggle now. And so it's not for the people. I agree with Mr. Hoskins. Bring it up to the vote of the people. I rest my case.
Mr. Thornton?
Tom? Yes, sir. Does this enable first degree to file contracts with the Cherokee Nation? I believe, let me get the contract portion. I believe it does with disclosure. That would be Section 28, or Title 28, Section 11A, which would be the third page of the Act, about midway down. It states where an employee or their spouse or an official or their spouse has ownership interest in a business in the Cherokee Nation or its instrumentality, that business, no conflict will exist as long as it's properly disclosed, it was based on favorable pricing, there was no solicitation, the business was chosen without the input of the employer or the official who maintains it. The employer or official is not in the department or agency of the nation or its instrumentality which is doing business such as. So, I mean, it would allow first degree, it would also allow the official itself.
Well, then it is allowing the official himself of the first degree. Then we're not just talking about a paycheck, we're talking about hundreds of thousands of dollars, maybe millions. That will go out to a legislator here and their family, and there's just no way I can beat with this. Thank you.
Ms. Watts?
Thank you, Mr. Chair. I really am struggling with this issue because my concern is not some of our employees who've been with us 10, 13 years, way prior to somebody sitting on this council, and it's not only just a separate branch of government, but a separate entity, who have disclosed their relationship with the council, and that's required by CNE, I think. Councilwoman Yargy was kind of asking about that. What do they do at CNE and CNI? Well, they have to disclose that. That's part of their ethics report. My concern is some of the relationships that already exist on this council with business entities where they've transferred ownership, housing authority, rental property to their wife and their daughter, and those aren't disclosed and aren't known publicly, and we're talking about millions. Or we're talking about maybe smoke shop interests that have been rumored. I would rather have those not be rumors, and I would rather have those publicly disclosed and draw what you call, the legal term, bright line, so that everybody understands and knows, and those are publicly documented, and we're done with it. No more rumor mongering. We understand what those relationships are. And to me, this lifts us out of that gray area and the rumor mongering and everything else, and validates our government as a sovereign government that we can manage our own household, 250,000 plus or not. But some of the amening and everything else that have been going on have frustrated me today, because I know some of the relationships and the public documents I've seen that aren't the same picture that's being painted in this room. So I'm going to be supportive of this today, because I would rather everybody know who's who and what's going on than continue on the path that we've been doing, trying to bash people, and they're people who are making not hundreds of thousands of dollars, making and earning a living, that they got these jobs way before anyone was ever on council or anyone was thinking about any of this. So, thank you, Mr. Chair.
The question's been called. I have nobody else listed to ask questions. Is there anybody else, real quickly, that has a question before we vote? Audra?
I'll just make a quick comment. I know a 22-year-old back in 1991 that had just started in a nice position with the tribe, and her dad got elected onto the tribal council, and she was told she had to resign. And we knew that going in, and yes, that would be me. And I had to leave the tribe in a position that I, had just been in about 6 or 8 months. Truly enjoyed working for Miss Kelly over in what was being tribal services. And, I left here a bit upset that I had to leave, because I think there were a couple others that ended up getting to stay by some rule or something that, had occurred, or by contract or whatever, however it was listed. But, that gave me an opportunity to go and work in another area, to go into work for a different program that wasn't funded by the tribe, and which I'm still with today. So it's not necessarily a bad thing, and I'm not saying if I had to do it, so does everybody else. But I believe that I have to agree that appearances is a big thing out in the community. And if you're out in the community and you're listening to people, they want to know they want to know why so-and-so's working here and so-and-so's working there, and who's kin to who, and they've heard this and they've heard that. And I feel like if we lift these laws, then we open that up even further. I feel like we do not protect the integrity and the ethical positions that we hold. And so I'm going to have to not support this. If there's some changes that need to be made along the lines that Councilor Watts referred to, then let's make some of those changes, but not so drastically that we just open it up totally like this act does. So those are my comments. Thank you.
Phyllis, real quickly.
Sorry, Mr. Chairman. But she took part of what I was going to say, is that then if we cannot pass a law, an act that would more clearly define a disclosure statement or whatever, then I would like to see this definition of the relatives added to the consanguinity definition of what we have currently, so that it's more clear. There's not that gray area. It would be more clearly defined, and not have all this other changes, but just to include that set of definitions. Does that make sense?
Instead of referencing who, you list who would be in that relationship,
right.
So someone could just read it and go, okay, that's the relationship.
All minds clear? Roll call vote on this, please. We have a motion and a second for approval.
Chuck Hoskin,
No.
Bill Johnson,
Yes.
Taylor King,
No.
John Keener, Jack Bob Martin, Linda O'Leary, Melvina Shophouse,
No.
David Thornton,
No.
Cherokee Watts,
Yes.
Phyllis Yargy,
No.
Bill Anglin,
Yes.
Bill John Baker,
No.
Jack Baker,
Yes.
Audra Connor,
No.
Meredith Fraley,
Yes.
Don Garvin,
Yes.
Joe Crittenby.
No.
Seven yea. Nine nay.
Okay, motion failed. Next, we go to item 2. This is the one dealing with the adding provisions relating to the Cherokee Silver.
Mr. Chairman?
Yes, Doctor.
Yes, we are moving to, we would like to withdraw that for further study, please.
Okay.
Permanently withdraw till you bring it back later in another form.
Yes.
I have a motion and a second. All in favor, aye?
Aye.
It's withdrawn.
Thank you.
Thank you, ma'am. Next, item 3, the duties of the Office of Marshal. Sherry?
That today, did you receive that amendment today to the one that you already have in front of you?
Sherry, I think they're being handed out right now, so we...
Mr. Chairman.
Mr. Baker?
We've got a long deal, and I guess we're just now seeing new amendments. I'm going to move we table this and give everybody time to read it before next month.
I have a motion and a second to table this so we can have time to look at it and read it. All in favor, aye? Aye. Any opposed? Thank you, Sherry. Next, we have item 4. This is a legislative act relating to the duties of the Attorney General. Mr. King.
Thank you, Mr. Chairman. We've been working for several months here with the Office of Attorney General, and I would like to yield my time to Ms. Johnson, if she would.
Okay. Welcome, Ms. Johnson.
Hello. Can you hear me? I'm pretty far from that. I don't know if you can hear me. I think that in your packet, the one that was sent was not, or the one that's in your actual packet isn't the right one. It should be the one that has a little header on the top.
Do we have copies of that?
Yeah, with the blue header that says Revised Act with T. King's Amendments.
It's 8.5 by 11.
Yeah, you got it. It's separate.
This is the one that should have been in the packet. There were 2 different versions. They got mixed up.
Next thing.
Okay.
Becky, maybe we can highlight what those changes are.
Oh, okay.
The first and foremost was one around independence of the Attorney General office.
Okay. If you recall, several months ago, we had turned in an act, and then there were some concerns about it, and I worked with Mr. Keene and Mr. Hembry about some language that would ensure the independence of the office. So a couple of the things that are relevant to that, I don't know if there are page numbers on here, but probably about the 4th page in, you'll see a number 12.
Third page.
The third? Right, and number 12, at the end of that, we added that last sentence. It says, provided further that in order to preserve the independence of the Office of Attorney General and to avoid actual and perceived conflicts. Basically what that part is about is to say that we won't provide the day-to-day legal advice to the principal chief or the deputy chief, so that there won't be concerns about us representing the nation itself and then also giving the chief advice on how he's supposed to handle his business that is more specific to the chief's office and not just the nation as a whole. I know it's kind of hard to separate the two.
I have a question for Mr. Baker.
But under this, it wouldn't change that the Attorney General is also head of law and justice, which does do those other things.
Well, I have to admit that I don't know what Law and Justice was before and how they were separated. I wasn't here when it was Law and Justice. When I came, it was called the Justice Department, and then there was a General Counsel, and all of these different. I'm not really sure what all of the different ones did in the past. So
who directs the law now, or justice, or whatever we call it?
I'm sorry?
Who directs it now?
Who directs it? It is under the Attorney General's office. And basically, I think what happened before is that Law and Justice maybe represented the chief. Is that accurate? I don't really know. But I think that what the concern is that there's people who represent the chief, and then there's people who represent the nation and do the day-to-day legal work for the nation itself, which is your criminal prosecutions, child welfare, and all of the things that are listed in here. Actually, a lot of that is done by the Justice Department now. As far as day-to-day legal advice for the principal chief, I believe this principal chief is elected not to hire counsel because he is an attorney, but this particular act says that we won't provide that day-to-day advice, and nothing prevents either the chief or this council from hiring the attorneys as you see fit to give you your advice, and also the chief to give him his advice.
But my problem is, if you call it Justice Department, represents the departments and represents the chief and does those kinds of things, and they're supervised by what we call the Attorney General, and there is a conflict, then isn't it the same thing? I mean, she's supervising them, and yet she's the watchdog for the people. And I'm saying a glaring of lines here, and I don't know that the Attorney General is ever going to be independent if she directs law and justice, or justice as you call it now.
Okay. What the Office of Attorney General, I don't know what will happen with law and justice or whatever, but what the Office of Attorney General do are these things that are listed in this act.
But she's wearing a second hat.
Which is, I'm not sure what the second hat is, I guess, is what.
She is over the Justice Department. She's over
and this will be what the Justice Department does, the things that are outlined here. And that's what this act is about, is for this body to determine what the duties of the Office of the Attorney General are. And it specifically exempts giving legal advice to the principal chief. That is not a duty of the Attorney General.
Let's say that justice that our Attorney General oversees gives advice to the health department, and it's bad advice, and we lose money, or it's done wrong, and now we need the Attorney General to investigate it. But her people have given the advice to do it that way because she's directing those attorneys. Am I making sense here? Or?
No, I understand. I just understand what you're saying, but I don't know where that would necessarily come into play, where somehow the lawyer's advice would be investigated.
Drew Edmondson giving advice to the River Commission, and then all of a sudden they're discriminating, and he's giving them the advice, and then who are you going to go to?
Well, in that instance, when you're, let's give the example of the Office of Attorney General advises our health department to discriminate against somebody. Then that is an offense by the Attorney General, and only this body can take action against the Attorney General. I mean, that's a constitutional question. But Drew Edmondson does. I mean, if your question is, Drew Edmondson does give day-to-day advice to different departments in Oklahoma, different departments of the state. There are some departments that are large enough that they have their own attorneys, and that happens here as well.
Ms. Watson?
Thank you. When you read the new provisions of the Act, it says explicitly that the Attorney General, regardless of what titles are around the org chart, is not to give daily legal advice if this was adopted to the chief.
Correct.
And the deputy chief, which is what what I think folks are trying to preclude, that bright line, right?
I think so.
Okay, so it's just a matter of semantics, it sounds like, with the org chart and some old terms hanging around, but we've changed the duties if we approve this.
Right. The duties that are listed in here will be what the duties of the Office of Attorney General are. Now, if you're talking about should there be a whole separate legal department
that's a different
that
question.
gives advice to the other departments, then you're going to be duplicating services and have two gigantic departments.
Mr. Chair, I'd like to move to approve.
I have one other comment here from Mr. Thornton, if he can. Go ahead, David. Move to approve.
Second.
Okay. Go ahead, then, David.
Move to approve.
Move to approve.
Todd,
Yes, sir.
have you went over this?
Yes, sir, I have.
Is there any conflict of interest in this?
Well, there's going to be an inherent conflict of interest in any attorney general position, be it the United States or or the state of Oklahoma, for example. If you look at the United States Attorney General.
No, we're looking at this attorney.
Okay, but it's still, you know, it's I guess the answer to the question is, yeah, there's going to be some conflict of interest, but there's a conflict of interest in Drew Edmondson in representing, you know, if something goes wrong in the state, and there's, and with Mr. Attorney General Gonzalez, if something goes wrong with the United States. So,
thank you.
I have a motion on the floor to approve this. I have a second. Anything else before we, what?
Sensing that there might be some.
We may have a roll call vote here.
Jackie Bob Martin,
Yeah.
John Keener,
No.
Taylor King,
Yes.
Bill Johnson,
Yes.
Chuck Hoskins,
No.
Don Garvin,
Yes.
Meredith Fraley,
Yes.
Joe Crittenden,
No.
Arthur Connor,
Yes.
Jack Baker,
Yes.
Bill Baker,
No.
Bill Anglin,
Yes.
Phyllis Yargy,
Yes.
Carol Cowan Watts,
Yes.
David Thornton,
No.
Lavonda Shophouse,
Yes.
Linda O'Leary. 11 yea, 5 nay.
The motion passed. Moving on to item 5, the Cherokee Nation Administrative Procedures Act. And the reason it was tabled, there was some questions about Section 306, I believe, last meeting, some emergency rule situations.
That is correct. I had a question about the implementation of Section 306 of the chief having the sole responsibility of implementing the emergency clause in this act. Mr. Paris and I have communicated, and he has sent over a revised Section 306 that I find very good.
Do you have copies of the revisions to 306? In your packet, I don't know if I have copies.
I don't know if
I don't know.
Do we have
I know you sent out
copies of the 306? On the Administrative Procedures Act?
The revised Section 306 sets a deadline as to the amount of time an emergency clause can be put forward. You
didn't get copies?
I don't think we've got copies.
Okay.
Ms. Fraley, do you have one? Did you get copies?
It's in the packet.
It's nice.
It's in the packet. I mean, okay.
Not the same one that I have.
Mr. Chairman, what I would recommend that we move this item to the bottom of the list. We will make copies of it, very short section, very self-explanatory, and possibly take this up at the end of today's meeting.
Same one we had last month. We had
I have a motion to move this to the bottom in a second. All in favor, aye? Aye. Opposed? Okay. Next, we have the Donation Act.
Your Honor. I didn't motion to This is, Miss Callan Watts has asked this to be withdrawn.
Withdrawn? All right. So, we're done. Next, we have the Corporation Reform Act.
You should have before you the Corporation Reform Act sponsored by Mr. Bill John Baker, and it has a litany of reforms to the Corporation Act. Those reforms mirror the outline that you've had in your packet for a couple of months now. It's very lengthy, and I'm sure our esteemed treasurer has something to say.
Thank you. I have not seen a copy of this proposed act, so I would request that the council table this.
Second.
I had a motion from, was it Mr. Martin?
Yeah.
Seconded by Mr. Garvin. to table this. All in favor, aye?
Aye.
Opposed, same sign? Aye. Two, you got it? Okay. Thank you, Kelly. Anybody got anything on the codification update?
Yes, Your Honor.
Your Honor. Your Honor.
He's from Adair County. He deserves to be an honorable. In your packet, you will have before you a memorandum to Melanie Knight and Diane Hammonds concerning, from Oklahoma City University, who is helping us now in our codification project. As you can tell in the memorandum, this is a tough project. It really is, and it's going to take more than I know we hired Ms. Teague, and Ms. Teague gave it her best shot, but it's more than a one-person job. It's a team job, and it's a codification committee job that we're going to need to really just bear down and get it done. And it may take some additional funding, but right now this is all voluntary. But eventually, I'm sure that the administration is going to come with a budget modification to expend some funds on this. I guess the very long story made short is that there is work being done on it, progress is being made, and by the end of this term, we hope to have a set of books and CDs codified in all of our statutes, so everyone can see them everywhere.
Ms. Frank.
Did you say we need some funding to continue this?
No, we don't. This is all volunteer work right now, okay? I'm just saying that at some point, I'm sure the administration's going to come with a budget modification to do that.
All right.
But I would just ask this to be a regular report each month and to hold our feet to the fire and make us do it.
We need to make a motion.
Yes.
Move to add that codification report for the time being to the report section.
I'll second.
Had a motion by Terry, seconded by Mr. Jack Baker to make the codification report part of the report section. All those in favor, aye?
Aye.
Opposed? Okay, so pardon? It looks like we've been given a copy of this section 306, and we can call this the bottom of the old business, and we can take that up right now if you'd like to.
Whatever the pleasure is of the council, if you want to give them some more time to read it, it can be at the
I
bottom.
think Mr. Cripps is at the bottom.
He's at the bottom of new business.
So it's wrong. Okay. Corrected. Thank you.
Okay. Todd, you want to go ahead and do this one now? 306?
I would be happy to. That's the pleasure of the council.
Okay.
As you will see, the previous version of 306 said that the principal chief could call an emergency or urgent commercial issue, and it remained in effect indefinitely. I thought that there was some inherent problems in that. Brought it up to the committee. Mr. Parrish diligently worked on it, and as you will see that there is now a time frame that an emergency rule may not be in effect for more than 90 days. Is that correct? And I think that would give, within 90 days, obviously there would be time for a meeting of the or any other body that would need to take action, and I see no problem with the new section 306.
Mr. Baker?
Sure. Todd, can you give us an example of where this might apply?
I would defer that to Mr. Pierce.
Okay.
Typically, it'd be, an urgent commercial. There could be a scam going on at the casino might come to mind, and under the current C&E regulations, the Gaming Commission regulations, it's perfectly legal, but it's not fair. And the Gaming Commission may say, we've got to put a rule in place today to stop this scam that's going on. This just comes to mind. And then they've got 90 days to either make that a permanent rule or rescind the rule or do something with it.
Another example would be, and this might be foreshadowing the future. Let's say the state of Oklahoma does something very adverse. The Oklahoma Tax Commission does very adverse to our smoke shops. And that we may need to take some beneficial action through our own tax commission to counteract that. This would allow the chief to call an urgent commercial issue and go in effect immediately until such time that the tax commission could could meet and approve it or deny it or whatever. But it wouldn't be in effect indefinitely, and that was my problem with it.
Let me understand. The chief can do this now. It just goes on indefinitely?
No, we don't have the...
Or you don't have the power to do this at all?
Right now, without the Administrative Procedures Act, an agency can do... They don't even have a time frame for setting a meeting. They can call a telephone hearing and set a rule in place, and none of these time frames for public comment will not apply. Once you have 30-day comment periods and all the material in this full act, then they would need an emergency rule. Right today, they don't need anybody's permission to put a rule in place immediately. It's essentially all of the rules they do are emergency rules. But when we put these time frames for public comment and whatnot, then they can't do what they're doing today and put a rule in place immediately. They have to wait. But there are occasions a lot of occasions when they do need to put a rule in place immediately, and we don't want to remove that power from them. There's a lot of it occurred to me, I've heard a lot of news about the Homeland Security Department taking fire for can we handle the next flu epidemic or can we handle the next hurricane. And you certainly wouldn't want to tie the hands of an agency to say you can't do anything to respond to that emergency for 90 days because you have to have notice and comment, when there's people getting sick or dying or whatnot. So we kind of gave some commercial examples, but it's primarily public health, safety, and welfare that a lot of our agencies are out there to take care of.
Mr. Garvin?
Mr. Chairman, this sounds like something that we need in the bylaws, so I'll move for the approval.
Second. Have a motion and a second to approve this. All those in favor, aye? Aye. Opposed, same sign?
By
acclamation. Excuse me. Thank you. Yes, ma'am.
I'd like to make a motion to amend the agenda again to add Mr. Cripps to item 1 under new business. He's been here for a while.
Second.
He's been here a long time.
I have a motion and a second to move this reappointment of Judge Cripps up to new business, item number 1. All those in favor, aye? Aye. Opposed, same sign? So done. Who's going to? Okay, Ginger.
On behalf of the principal chief, we would like to renominate John Cripps to the district court. And he's here to answer any questions.
Second. I have a motion by Mr. Martin and a second by David Thornton to approve. Any discussion or any questions for Judge Cripps? All those in favor, aye? Aye. Opposed, same sign?
Aye. Appreciate your comment.
Two.
Appreciate your comment.
For the record, was it not unanimous? No.
We had 2 nays.
Okay, thank you.
Thank you very much.
Thank you, Judge. Next we have what was old business number 2 and now new business. It is number 2 again. This is dealing with citizenship of the Cherokee Nation Code. Mr. Moore.
Good afternoon.
Afternoon, sir.
This basically has 2 parts to it. The first part is to bring the statutory language in line with the ruling decision JAT 0409, the Lucy Allen case, as well as make the language mirror that of the Constitution. The second part, if you go to page 3, the second paragraph, it was originally as a number 3. it actually strikes out one of the classes of people that can be a sponsor for a minor child for purposes of disenrolling them. And if you go to page 4, it is listed as Section 7, and the reference code is Section 34 regarding relinquishment. It actually changes the process for relinquishment from, it's taking it out of a court process and putting it into more of an administrative process where you go in, you fill out a form, you put the required information on the form that says, I wish to relinquish my membership in the tribe. And I believe it also makes that, as soon as the form is correctly filled out with all the information required, it is instantaneous. It takes effect. There's no longer a waiting period of how long before it becomes effective. I believe it also...
A motion to approve in a second. Any comments, Taylor? Mr. King?
Yes, I'd like to give my time to Mr. Henry to help us understand this, please.
This act, and I wasn't in here for all of Mr. Morton's explanation, which I'm sure was copious and convincing, but it is to codify, correct, the Lucy Allen decision as part of it.
Yes, and it just mirrors the language that was contained in the Constitution.
Okay. My problem with that is that between now and our next regular council meeting, there will be an election that may have drastic ramifications on the Lucy Allen decision. I would request that you table this, and if so, I do believe that the part about the relinquishing citizenship needs to be addressed prior to the election, but I don't think that it needs to be done before our special election that's going to come up, like I said, between now and our next regular council meeting.
Motion second. Okay. Mr. Martin had his hand up before we had that motion. Do you have a comment, Mr. Martin?
Yes, Mr. Chairman. The motion, and I appreciate, I just had some questions about it. I agree with the legislation, but, and asked Mr. Morton before the meeting, but didn't have time to really discuss this. And looking at this, and some of the, I have highlighted here. You get over in page 3, and several places through the piece of document, you take out the part about Cherokee blood. What was the reason for this? From the original language, why did you strike those phrases out?
So that's part of the complication of the Lucy Allen decision. Okay. Now,
that's why I'm asking. I want to know.
Yeah, it's basically based on the Supreme Court decision or JAD decision in what we call the Lucy Allen decision. We couldn't have any citizenship restrictions for by blood. Okay. It would be just to the Dog Growth Commission. That is what, in the way we said, codifying the Lucy Allen decision. When there's a Supreme Court decision, which is the law of the land, the statutes have to change, the laws have to change. So we have to take that wording and incorporate it in our statutes. The reason for I recommend to table this till next month is that in between that time there's going to be an election, and that there's going to be ramifications as to the Lucy Allen decisions based on how that election goes.
Thank you, Mr. Chairman.
Well, I have a motion on the floor to table and a second. All those in favor, aye? Aye. Opposed, same sign. Okay, motion carried. Next we go to item 3. This is the legislation dealing with the tobacco tax and allowing for the repeal of certain sections. Eric?
afternoon. What this act is I know there's been a similar act in front of you on several different occasions, but what this act does, it removes the proposed tax rate that has been in the previous one, and it's kind of a safety net, I guess I would call it, for our retailers. In the event that we do not have a compact with the state or an adverse decision in a tribunal, what this does is it causes a safety net to allow us to be able to provide product to our licensed retailer shops out there. And there is no rate in this or anything, but that's all that this allows for. And there is a trigger in there that says it can only be implemented upon those certain things. Either we don't have a compact or there's a adverse decision in a tribunal or within those decisions. And I would also like to say that Mr. Joe Lane with the Tobacco Retailers Alliance is not able to be here due to some health reasons, but he does support this. We have spoken with him, and he is in support of this act.
Mr. Baker, do you have your hand up?
Yes, I do. Many times we make motions and such for our constituents, and this is one that I'm going to make to not pass this. I make a motion that we deny this.
I'll second.
Discussion, Ms. Watts?
Thank you. I thought this was something we've been working towards for a while. This was like going to benefit the tribe and benefit smoke shops. So I'm confused myself it's not in
And if it...
Mr. Baker's first.
Yeah, we have worked on it a long time, and we did table it permanently. And we mold it up, down, sideways, inside, outside, and finally decided that our smoke shop owners did not want it, and we permanently.
And this is a different format, right?
And so they changed 2 words or 3 words, and it's coming back. So yes, we've worked on it, and we've tried, and we've talked about it, and we've made a decision. And now we're going to take another bite at the apple.
Go ahead, Sharon.
And if there's issues with this, we'd like to work this out. I would ask that we could table it and possibly work on it. And from that point,
I've got Mr. Martin had his hand up next. Mr. Martin, you got a question?
Yes, Mr. Chairman, thank you. How many smoke shop owners do you have in the audience? I would like to have heard at least give each one a minute of time to speak on this issue. That way it might give me a better idea of what we need to do about this. Would that be possible? If they would? Yeah, I've got a gentleman back there in the back that would.
I'd like to have somebody speak from the smoke shop group back there anyhow. Chuck, just relax.
Good afternoon.
Afternoon.
Name's Dan Carter from Gore, and I'd like to thank you for giving me the opportunity to speak here on this issue. The smoke shops are actually not, this is an issue where we're not opposed to the tribe helping us on this matter, and we think that their motive is to protect us against a future state regulation or rule. But the problem is we feel like the tribe doesn't fully understand that they're probably not going to be able to attain the products that we need to sell. That's what I believe, and I think that's what the majority of the smoke shop owners that I've talked to believe, and not their fault. It's just an intimate knowledge of the business that Philip Morris and those major companies are not going to sell these products to the Cherokee Nation. It's already been looked at over on the Creek side, which the Creeks do have a wholesale company that they have several problems with going right now. It's not that we're not opposed to Sharon and them helping us. We'd like to thank them for that. But it seems to me like the rule that you just passed pretty much solved all of our problems, because that gave them the opportunity to come in here and ask you guys for emergency rule. If the state does something to adversely affect us, then they can come in here and ask you for that. We can all look at the deal, and then if the state does step out there and do that, you have the opportunity to pass this then. And if that's the only choice we got to go that route, we might have a different opinion, but as it stands right now, we just flat don't think that the Cherokee Nation can obtain the products, and that's our basic problem with that. We see no way that they can buy from another wholesaler, from an out-of-state wholesaler. We looked at cases that's been done in Washington in the past that kind of got in trouble over that deal. So that's pretty much our position on that deal.
Thank you, Dan. Mr. Thornton?
He's answered all three of the questions.
All right. Next I had Mr. Garvin. Sharon, go ahead, though.
I just wanted to say that is a rule and not a law, and he's right. And we have contacted some other wholesalers in the past, and we had found one that was out of state that was willing to sell product to the nation in the event that we became a wholesaler.
Thank you. Mr. Garvin, I think you were next,
I
sir.
think Mr. Carter had some good points, and I appreciate his remarks, and I think this needs a lot more work, so I'll make a motion to table this until...
I have a motion to table and a second. All in favor? Opposed?
Thank you.
Okay, thank you, Sharon. Next we have an act relating to the duties of the delegate to Congress. Oh, excuse me, Mr. King.
Thank you, Mr. Chairman. In our 2003 Constitution, one of the historic movements that was made was to look at our old treaty rights to prescribe a delegate to Congress, and this act simply would bring that into law and allow the principal chief to nominate someone who would be then to be confirmed by this body. And if you can add a little bit more, please.
This is a piece of basically implementing legislation. It provides a few guidelines, a little bit of guidance on who can be the delegate. Follows the rules of the House of Representatives right now, and it's an important first step in moving towards claiming that treaty right that was in the Hopewell and in the Minnesota treaties.
And with that, I'd like to make a motion to approve this.
I have a motion and a second. Who's second? Audrey? Okay. Any other discussion? Ma'am, for the record, your name, please?
My name is Sarah Hill.
Sarah Hill, sorry.
I'm a staff attorney with the Justice Department.
Thank you very much. And I apologize for some of us right here didn't realize. Okay, this is an act. Roll call.
Bill Anglin?
Yes.
Bill John Baker?
Yes.
Jack Baker?
Yes.
Audra Connor? Yes. Joe Crittenden?
Yes.
Meredith Fraley? Yes. Don Garvin?
Yes.
Chuck Hoskin?
Yes.
Bill Johnston?
Yes.
Taylor King?
Yes.
John Keener?
Yes.
Jackie Bob Martin?
Yes.
Linda O'Leary? Nobody Shophouse?
Yes.
David Thornton?
Yes.
Carol Callen Watts?
Yes.
Phyllis Sharp?
Yes.
Unanimous. Next, we have a legislative act related to gaming within the jurisdiction of the Cherokee Nation. Jamie, you doing that one?
Thank you, Mr. Chairman. The act that you have before you is simply a clarification of some existing language. We noticed that there were a couple of not necessarily discrepancies, but some things that needed some clarification in the previous acts that were approved by this board, approved by this council. We wanted to clarify this before we proceeded any further as to the actual licensing of gaming facilities and the requirements thereof.
Mr. Thornton's got a question.
I'd like to make a motion to approve this.
Second.
I have a motion and a second for approval. Any discussion? Any questions? Okay. This is also an act. Let's do this one by acclamation. All those in favor, aye? Aye. Opposed, same sign.
Thank you very much.
Thank you, James. Next, item 6 is discussion and possible action concerning appeal of Legislative Act 3905.
As the members of the council are aware, Ms. Hammonds and myself put forward a declaratory judgment action asking 9 separate questions concerning the Constitution and the upcoming election. We received on February 12th our answer to each of the questions, and I am here before you to ask guidance of my clients as a whole of where do I go from here? Which questions do we appeal? Which questions are we satisfied with? If any, are we satisfied with the order in toto, or do any of you wish to, or do a majority of this council wish to give me the direction to appeal? I'm still within my time frame, and that's why I wanted to put it on this agenda.
Ms. Watts.
Thank you. Is it too late to add a constitutional amendment to the June election concerning the residency requirements for council?
Yeah, I believe it would be.
What's the wishes of the council as far Mr. Thornton, excuse me?
Todd, on these answers, do you feel that they're all following the new Constitution?
I mean, how I feel is irrelevant at this point. Yeah, it's we have an order of the court, and and I got to have my my clients to decide whether they are satisfied with these answers. I have said on a number of occasions that I felt that there needed to be 15 separate districts. At this stage of the game, even if we appealed that question, could we implement 15 separate districts? I think at this point it is logistically impossible.
Well, if you appeal now, you can settle out later. Are you saying that you think that you should wait till after the election to appeal? I mean, this is in this is what the justice come up with.
Well, this is what the judge has ruled. Okay, and if you go forward with an election under this rule without it being appealed, there probably wouldn't be a very good opportunity for anyone to later challenge that constitutionally. Now, after a new council is elected, should they go back and try to do districts and for a true one man one vote? I would recommend that. I've recommended that all along, and I felt that the Constitution required separate districts. The Attorney General disagreed with me, and Justice Cripps disagreed with me.
Then what you're saying is anything in this, we can appeal it after the election.
You could either you couldn't appeal it after the election. You'd be out of time to appeal it, but you could correct it legislatively.
Okay.
Mr. Hoskin, you're next.
Todd, anything that you have to say certainly is not irrelevant.
Okay.
But my concern here is that we, as your clients, are directly relying on you for some advice here, and that's one of the things you get paid for in addition to your outstanding writing ability. But so really, I'm looking for some direction here. Obviously, I disagree with some of these. I agree with some of them. But we're looking from our attorney's standpoint. What kind of advice would you give us here to not appeal at all, or appeal over 3 or 4 or 5?
In that regard, I would like to go question by question. Okay. The first question, does Article 6, Section 3 of the Cherokee Constitution call for one counselor to be elected per district and thus require 15 separate districts to be developed within the Cherokee Nation jurisdictional area? The answer was no. You've just heard my explanation. I believe that the Constitution does require 15 separate districts. The Attorney General disagrees with me. This judge disagrees with me. That doesn't change my opinion. But logistically, I believe it would be impossible for us to go forward and try to correct that at this stage in the game. I believe that is something that can be corrected legislatively after the election. And that would be my advice. Any questions on that?
Mr. Baker? Yes. Could someone immediately after the filing period file a lawsuit stating that we have to have the 15 districts and then stop our election from taking place in June?
That could happen, but with this decision not being appealed, any challenge to that lawsuit could raise res judicata. The decision's been made. Okay? It's been decided by a court of the Cherokee Nation, and that decision was not appealed. So therefore, it became a final ruling.
So why wouldn't we appeal that?
That's why I'm here for you to tell me that. I've given you my opinion. Okay, next. Question 2. Does the proposed plan provide for a reasonably equal division of citizenship among the districts as required by the Constitution? By virtue of the proposed plan having been previously vetoed by the principal chief and not in effect or pending, this court will not make any determination on the potential conflicts until they are pending for decision. What I think the judge meant to say there is that it's based on his decision, his answer number 1, the proposed plan is really irrelevant because he ruled that there didn't need to be individual districts, so therefore, is the individual district plan competent? And he didn't answer that question. Question 2B. In the current districting scheme under Legislative Act 3905 is maintained, which is what we are under now, should the number of council members per district remain the same or be increased/decreased proportionally to the data provided by the information systems? Answer. The number of council members should be increased or decreased in order to allow proper representation proportionally by the separate districts, which that means based on the information that is eventually used, if we have that information, those council districts should be increased or decreased proportionally.
So do I make a motion that Cherokee County get a third seat at this time, or?
That would...
I make a motion that we give Cherokee County the third seat.
Second.
I have a motion and a second on the floor.
However, what we're going to need to do in order to do that is there needs to be a decision on question number 4 about the data used.
Thank you.
Now, under question number 4, which is, did the council use reasonable data to apportion the representative districts in Legislative Act 3506 in that they used Cherokee voters by zip codes and then proportioned those numbers based on the percentage of land mass of border zip codes with the jurisdictional boundaries? Or should citizenship data provided by voters declaring their county of residence be used? The court ordered citizenship data provided by voters declaring the county of residence should have been used. The court is cognizant that many different variations of information may be used by the tribal council in determining apportionment. The best available information should be used. In registering for membership of the Cherokee Nation, individuals declare their county of residence. This is direct and concise information that needs no variant or explanation. This information comes from the citizens, his or herself, and is signed and attested. If a question arises as to actual residence, a protest may be filed. So, the court ordered that we should have used information that we did not. So, in order to proceed with reapportionment or redistribution of council members, we would need to appeal question number 4.
Mr. Keene has a question.
Thank you, Mr. Chairman. Perhaps I'm oversimplifying this, but I think all of us probably have a different opinion on every one of these. So I'd like to make, to me this needs to go to our Supreme Court and it needs to be addressed. So I'd like to make a motion that we appeal every single one of these separately to the Supreme Court.
I'll second.
Appeal all nine questions. I would also add this, that if we appealed all 9 questions, I would invite each council representative who would be an interested party to file amicus curiae briefs or whatever information that you felt relevant to the court to consider. I will do my bidding, but everyone else should each one of you has a right to tell the court what you think should happen.
Mr. Baker and then Mr. Martin.
And I'm not sure the judge understood that all of Rogers County was not within the 14 counties of the Cherokee Nation, that there is a portion of Rogers County that they could have declared that they live in Rogers County, but that doesn't put them in the 14 counties. And if there is a population change, from the information we've looked at, it's between Buell and Cara and not between any of the rest of the Cherokee Nation. And most of the other places, the numbers are good with citizenship. And under either set of scenario, Cherokee County would get a third seat. So, if you gave Cara 2,000, took 2,000 away from Buell, changes nothing. Buell still gets 2. Cara still gets 1. It doesn't change. So I guess I'll withdraw my motion for a third seat, saying to appeal the whole thing. But should I come back with a motion for a third seat from this body?
You can on this agenda.
Okay. Go ahead.
Mr. Martin.
Thank you, Mr. Chairman. My question number 1 was, how many motions do we have on the floor?
We have one motion. One so far. I think Mr. Baker withdrew his.
Yeah, well, thank you. With that,
There's been a motion on the floor to appeal all 9 questions.
Yeah.
Call the question, Mr. Chair.
I had one other comment.
Oh, I'm sorry, I apologize.
Ms. Watts?
Thank you. First of all, if my memory serves me correctly, the election law actually says we cannot change anything to do with the election law, which would be the districts about 6 months prior to the election occurring. So number one, we can't do anything. But number 2, if I were to sue for reapportionment, Adair and Sequoia would both lose the seat. And because I looked at
It's Adair and Mays.
Adair and Mays, excuse me. And both Mr. Garvin's district and myself would potentially gain a seat each from those counties. And I would challenge that we have a Cherokee census. I mean, that little bitty corner of Rogers County, I'm sure I'll lose about 50 people, maybe 100. But I don't think it's going to impact the 13,000 that I should have, and I've looked at the data based on that.
Ms. Watts, me and Mr. Martin, I think are unanimous that we don't want to lose a seat, so you're not... Go ahead, Mr. Martin.
well, I'm going to ask Mr. Watt, where did she come up with all this information, where the rest of them are not aware?
Before if I may interject, that is precisely why each counselor I would encourage each counselor to put forward their own information, every bit of information that they would like, if we decide to appeal all 9 issues.
And Mr. Henry, I got a point of order over here.
Point of order is simply that we have a motion on the floor. The motion is to appeal the entire thing. We do have a second. Any and all discussion needs to be contained to that motion, not discussion of the issue.
Any other discussion aimed or pointing toward that motion? David had something? Garvin?
Well, it's been said that we can't make any changes within 6 months of the election. So, what we're doing is just kind of spinning our wheels or walking backwards. Now,
Mr. Henry?
Okay. I want to God, can the Supreme Court do anything?
Yes. The prohibition is the council cannot change the laws before 6 months prior to the election. Supreme Court can do whatever the heck they want.
Day before the election.
So we're proper in our motion to appeal, and we have a second. I think we ought to take a vote, seeing how the time's where it is. All those in favor?
Aye.
Opposed, same sign. Motion is approved. Let me see what else we got here. The only thing I see is a meeting date change and possible action. I've been requested to see if we could move the March meeting from the 29th to the 30th, which is a Friday. Is that right? Oh, I'm sorry, that's a different thing.
Or where people voted to,
No, Shelley has that.
That's why we're here. The Friday for a year. I was told we had to do it. Okay. Do you know what that is, what that amounts to, Todd?
Well, what this is there, what prompted this on the agenda is that there was a letter to garner the wishes of the council of changing permanently the meetings of the Rules Committee and Executive Finance Committees from the last Thursday of the month to last Friday of the month. And there was, and everyone replied in writing and was sent back in here, and it was a majority to change it. I believe that there needs to be a vote in council. That's why this is on there. And would ask that the poll be read and give anyone the opportunity to change, or give everyone the opportunity to confirm that poll or change their vote and have discussion on the same.
Ms. Watts?
Our Constitution does not allow for voting, what is the term? If somebody's not here, their vote doesn't count. By proxy.
Correct. Yeah, you have to be present.
So we can only take, I don't care about that poll, we can only take a vote here and now with who's present about changing this meeting.
That's why we're here.
Okay.
Mr. Baker?
I have a question. The purpose and the letter that was sent out was because Councilor Baker was to be seated on the grand jury. Was he actually seated on the grand jury?
He was not.
Okay. And the other point I have is that if we move it to a Friday, if the first of the month falls on a Saturday, we do not have 10 days before the next council meeting to have it posted on the agenda. And that will happen in September, December this year.
Mr. Garland?
Mr. Chairman, I think you need to leave it where it is. We've been meeting on Thursday for the last 3 years, and before that, longer and longer, and it creates a hardship on some of our people. When you start making changes and flipping around, it's not good. So I make a motion that we leave it on Thursday.
Second.
I have a motion and a second. I've got a couple of hands up. Mr. Austin?
Thank you, Mr. Chairman. Members of the council, at the time that Mr. Baker, I got the request for this on Friday, I thought, well, that could be a good deal for me also. And the reason why that is because having now a seat on the Oklahoma House of Representatives, we finish our business on Thursday, usually Thursday mornings. And obviously I would do the very best of my ability to get here. But if it is not that detrimental to simply move it to Fridays, and my request would be to move it to Fridays for the next 3 months. Our session ends at the end of May. And again, this is a personal request, but it's also a request of a tribal council member and a member of the Oklahoma House of Representatives. I consider it a great honor to be serving on both, and I want to do that to the very best of my ability. If we could do this just for the next 3 months, which would not get into the situation that Councilman Baker was talking about, the possibility of it not being an available Friday, I would certainly appreciate it. And again, I not only represent myself at the Oklahoma House of Representatives, but I also represent all the members of the council, and I take those things very seriously. If we cannot move it to Thursday, then I will still do the very best that I can to make sure that I am here and available to vote. But my request is just for 3 months. That the motion on the floor is not to have it at all. I would like to ask you individually to defeat that motion, and then I would like you to consider the possibility or consider the motion to meet on Fridays for the next 3 months. So, thank you.
And then Ms. Cowan.
We're talking about changing around. We've already changed 3 or 4 times since
last 4 years, we used to meet on Thursdays, Wednesdays, and Thursdays, and I never was asked if it was convenient for me or not, so we've made those changes, so why another change, what difference would that make? So, thank you.
Ms. Watts?
Thank you, Mr. Chair. It would create a hardship on me because I've scheduled my life around this time, and it would make it very difficult for me to get here from where I'm having to come from. And actually, it's impossible. So I had to change things today just to be here, and that's a one-time thing. I can't afford to do it for the next 3 months.
Well, the motion on the floor is to not change, I believe, if I heard it right.
Motion is to leave it where it is.
To leave it on Thursday, and I had a second. All those in favor, excuse me, Mr. Baker?
So if you vote yes, that means that it stays just like it is, and we don't give Chuck a chance, right?
I believe that's what I heard. So if you vote yes, you're saying we're going to leave it on Thursday.
Okay.
Is that right? Okay. Sorry, Phyllis.
I just wanted to also clarify the motion. I think that motions are made in the positive always, not to vote against something. So our motion should be to change as it's written on the agenda, rules meeting date change. So our motion should be to change the rules meeting date.
Todd, give us a quickie on it, would you?
Although most motions are made in the positive, it can be made in the negative also. We've had a couple of them made here today. So
I made the motion, and it was in the positive.
Leave it the same.
Where it is, that's surprising.
So there's not a problem with that.
The motion's in proper form.
So if we vote yes, it's going to remain on Thursday.
Yes for Thursday. That's yes for Thursday.
Okay. Roll call. Oh, I'm sorry. Did you have something else?
I'm still saying that we're voting up and down to change. If it's a no vote, then there's no change. It's just clarification.
No. Hold on. Clarification, please.
Yes. The motion that was made was to leave the meeting as it is. That's a proper motion. If you vote yes, you're voting to keep the meetings on Thursdays. If you vote no, you're voting to change them.
Thank you. And that's what I understood. So we're going to do a roll call vote. Let's have a roll call. Yes is to leave it Thursday.
Taylor King.
No.
John Keener.
No.
Jack Bob Martin.
Yeah.
Linda O'Leary. Nobody Shothouse.
No.
David Thornton.
No.
Cherokee Watts. Phyllis Yardy.
No.
Bill England.
Yes.
Bill John Baker.
No.
Jack Baker.
Yes.
Audra Connor.
No.
Joe Crittenden.
No.
Meredith Fraley.
Yes.
Don Garvin.
Yes.
Chuck Hoskin.
No.
Bill Johnson.
Yes.
7 yeas. 9 nays.
Mr.
Chairman, I make a motion that we move our 2 meetings to Friday,
Same time?
same time.
Have a motion?
Second, with a friendly amendment, it's only 3 months.
That it's only 3 months. Would you accept that friendly amendment?
Yes, I will accept it.
Everybody hear that? We're going to move it, the motion is to move to Friday.
And Mr. Chair, and it's 1:30 that we start. So it physically enables me to try to get here.
Except 1:30.
Oh, because it helped you get here. Yeah.
Okay, so it's for 3 months, and the meeting time would be changed to 1:30. That means we'd push executive and finance back to 3:30, I guess.
Or we could have all the reports in writing for the 3 months.
Okay. Is everybody kind of clear about what we just said? I think we can do this one. All in favor, aye?
Aye.
Opposed, same sign? Mr. Martin, did you have something, sir?
I have a question when we get through with our business.
Okay, and I believe we're through with that. We're down to the announcements.
All right, thank you, Mr. Chairman. Mr. Henry?
Yes, sir.
Todd, what do you prefer to be called?
I prefer to be called for dinner.
Okay.
Todd's fine.
Pertaining to a regular June election. You know, we settled the issue the other day about C, A, and B, whatever. Well, Mr. Clinton and I need to settle up. We need to settle something.
I need to step outside.
Well, yeah. Can we get that coin for
Anyway, we've met a couple of times, talked about this, and we can't decide, we haven't decided, I guess, who would get, say, seat A or seat B or 4 year or 6 year. Is there a written rule in our policy? So then, my question is, then, in front of the audience here, then we can settle that issue here today. About flipping the coin, do you agree with that? What seat you file for?
Yeah, and I don't know, this could be done, I guess, I don't know whether the northern part that we decided, I'm opening up a can of worms here for the committee.
Point of order, there's nothing on the agenda for this.
What I would recommend is that you and Mr. Martin get together and if you both agree on one of you to run for seat, for the 4-year seat or the 6-year seat, that you do so, but that everybody make their own individual decisions on it. That's the way I...
Mr. Garvin, you had something.
You gotta remember now, the Supreme Court may move your seat over to Muskogee and also to...
Could very well be.
We may only have one, Mr. Martin.
That's right.
Maybe we adjourn.
Second.
All in favor?
I was going to make that.
Excuse me, Chuck. We're adjourned.